And on today's show, why attorneys target advisors and not their companies and policies. Part 3 of this week's series on protecting your practice with best practices with prosecuting insurance attorney Ilya Lerma. Hi everyone, I'm Steve Savant, syndicated financial columnist and contributing author to Backroom Technician in Innsmark. Let's get down to business. Well, welcome to day 3, Ilya. There's a little bit of fear of God now in the last two. If you missed any of our episodes, you need to hop back out to downtobusiness.brokerage.com and catch our Monday, Tuesday show. We're talking about best practices all this week, and I'm telling you, if you've missed any of those two shows, you need to hear a little bit of how we've actually laid this out foundationally so your thinking will be really in sync. I think the chronology of our shows throughout the week really help us. Today, we're going down, and I have to tell you, even the savant has having problems with this because attorneys, I thought, well, isn't this all about the contract? Isn't this all about the company? No, you say almost all the prosecuting attorneys, they're actually targeting the advisor. I'm in shock. Tell me why.
Well, there's different reasons that you might actually target an insurance company over a producer. You might actually name both as potential defendants. Sometimes collectability is one of the factors you want to think about. Sometimes who you want in the defense chair defending their case against a jury is a consideration. But from my own personal standpoint, the way jurors look at these types of cases is because of the relationship. The extent to which a financial or insurance professional is going to be held liable is going to be highly dependent upon the circumstances in which the relationship was created. And many of these insurance producer relationships are cultivated over 10 or 20 years. And so when you have a relationship like that, it becomes more than, well, this is just a relationship with Allstate or this is State Farm. They can represent anybody. This is me and my personal insurance representative. And that relationship really is what forms the basis of the claims because your clients become heavily reliant upon the advice and recommendations that you give them.
So when I have a contract, it's probably easier. I'm assuming this. Please correct me if you think I'm wrong. It seems like it's easier to go after the advisor than it is to actually sit there and try to break out the legal language inside the contract.
No, I wouldn't say that it's easier, but it's a different type of claim. If you look at the insurance contract, that's going to be one type of claim. Breach of contract is itself a claim. But insurance producer negligence or insurance agent negligence, malpractice, is a different sort of claim. And it really stems from the fact that this is a professional who's holding themselves out to the public as someone who has expertise, training, and knowledge in order to lure that sense of security, that sense of protection. And they use that as a foundation to basically develop their business and their business practice. And so you can't promise the protection and the safeguard and then become this glorified sales rep when it comes time for your client to actually understand why they didn't get the coverage that they were entitled to.
How critical is it for a producer? Because I'm just thinking of the normal insurance producer who is selling a product, who he's been trained by from another company, from the company that's issuing the policy. I am not an attorney. I don't know legalese. I don't know contractual law. I'm just trying to make a living, and I sell the policy and all of a sudden I have to sit there and say, I don't even know what this said. If I don't know it as the producer, how can the client possibly know and be obligated to know it either?
That's correct.
And that to me is shocking to think about.
It's problematic. And I'll tell you, I've been in depositions where I have asked insurance professionals, well, do you understand the category of damages that your product purports to cover? Does this cover lost wages? I don't know. Does it cover loss of consortium? I don't know. Does it cover damages for emotional distress? I don't know. I don't know. I don't know. Those deposition transcripts read very, very well in front of a jury. And what's really frightening is that a lot of these insurance professionals who say, they may start out in the beginning of their deposition saying, yes, I'm an expert, I've sold this product for 20 years, I've sold this for this company for the last 15, I know every product that they sell, I've been committed to this, I've had this book of business for so many years, and then all of a sudden they don't know the very practical operation of some of the very simple products that they sell. Something as simple as, again, automobile insurance that we talked about before, that's frightening. And the insurance professionals should be really, really concerned that all they know is the selling part. Because if you don't know what that product actually protects against other than what you've gotten in your sales and promotion materials, your client could potentially be exposed. So as the professional, you have an obligation to educate yourself to know how, in practical terms, when there's a claim for auto injuries, what happens, what damages are covered, because then you will be able to better educate your clients about why they need this particular coverage.
I'm just thinking the normal producer is not there. And I think they were trained by the company on the sales, the practical sales mechanics, and not the contractual law. I don't know that to be a fact, but I'm just saying most of the training I'm thinking in my last 30 years, I don't remember anybody really going down that far.
But you're right, and that's one of the reasons that the company itself isn't necessarily the target, because and they'll leave the insurance producer out to dry to defend themselves in these cases. I mean, they have attorneys, they have their attorneys to defend these cases, but in terms of being able to explain why don't I know this insurance product better than I do, the insurance company is not going to help you with that. You're on your own. So if you're going to be on your own, institute some safeguards, some very, very simple ones, and find out what category of damages these products cover and what they don't cover, and what some of the dispute. Make friends with a personal injury attorney for 6 months and follow the anatomy of a bodily injury claim so that you can really know the inner workings. It doesn't hurt, especially if you're going to commit your last 30 years of your professional life to selling of insurance.
Well, I have to say, I'm just in shock and awe right now before we go to the break, because I just found out my insurance carrier may be cutting me out faster than everything. We come back, we're going to talk about why errors and omissions insurance may not even be the answer right after the break. Back in the day, life insurance professionals were called field underwriters. Then, carriers trained their field force in the basics of life insurance underwriting. Today, the insurance industry doesn't educate the agent population as they once did. But now you can have the Informed Risk Guide at your fingertips so you can illustrate a reasonable rate class for your life insurance prospects. Just request your copy of the Informed Risk Guide at downtobusiness.ashbrokerage.com. It's free from Ash Brokerage, the practice enhancement company. Welcome back to our second segment. Elia, I have to say, I'm so sorry because I've read so much contract licensing over the last 30 years where the contracts between the carrier and the insurance agent seems to be one-sided.
Very.
And so I can't really depend on them. Even if I've been producing them for 20, 25 years, if I get myself in a sticky wicket and I'm heading to litigation, I don't know if I'm going to get any help from my company that I've been so-called faithful selling all these years.
Well, you'll get the attorney, but understand that very often, especially if the company has been also named as a defendant, the appointed attorney is representing the interests of the insurance company.
Oh, yeah.
And it's not until there's potentially a conflict of interest. I think there's a conflict from the outset, but the defense attorneys may see it differently, and it's not until that conflict actually arises that separate and independent counsel may come into play. But that contract language really is about protecting the insurance company. And if we go back to our conversation about Arizona law, the statutes are in place to protect the company. But that doesn't necessarily mean that the company is protected, that you have that immunization or that isolation from claims. Because attorneys like me, and I tend to look at these as claims against the agent's own independent negligence, separate and apart from whatever training they may have received. You're still holding yourself out to the public and maintaining a living, and usually quite a good living, by giving professional insurance advice. And so you have the same responsibility as, say, for example, a medical doctor. If you hold yourself out in a category of specialty, then you have an obligation to know and be familiar with the skills and training of those in the field.
I'm just trying to think, after you've said all this, and most of us watching, we all have errors and omissions. Okay, and I keep thinking this is my defense, this is my insulation, this is the way that if I have a situation, I've been very blessed to 30 years, I've never had a negative ever from a client, thank you. But now I'm talking to you, I'm thinking like, hey, how about my errors and omissions? What if I ever have to use it, and is it actually, is it gonna help me?
Well, ideally it will help you. I mean, again, it's not like you're going to literally be hung out on the fence to dry by your insurance company, but understand, again, that the first motivation is to protect for the funds of the insurance company, irrespective of whatever it is that's being said to you. That's a huge consideration. It's much the same, again, using doctors as a bit of a context. When you sue a physician, the attorney that's appointed to represent the physician is hired by the physician's insurance company. And so the defense always comes as a result of the appointed attorney by the insurance company. And so if the physician actually wants to protect himself and come out with a certain defenses that perhaps the insurance attorney doesn't think will be beneficial to the insurance company, then you have a conflict. That's problematic. And so you have the same type of things occurring when you have insurance attorneys representing insurance agents versus the company.
But will my errors and omissions protect me? And I'm excluding fraud. I'm not talking about deception here. I'm talking about, hey, there was a mistake here. I either left something out, an omission, or I actually made an error in the statement that wasn't true. It wasn't intentional. It just was a mistake. Do you see in litigation, because most of the people that I know have errors and omissions, are they falling on their errors and omissions sword, or no? You are not looking for that as a financial way to justify damages, to pay for it.
No, I think in general, those types of claims, you are going to fall within the purview of errors and omissions. Understand that some types of fraud, negligent misrepresentation, et cetera, those types of claims don't require that the speaker actually know that they are misrepresenting certain facts. And you can still be held liable as a professional in that context. Generally, you're not going to be liable for types of punitive damage claims and that type of thing. But generally, you are going to find coverage from your errors and omissions carrier.
In your experience, when you go to arbitration or litigation, you're going to court, the damages have been awarded. Are they coming out of the pocket of the producer, or are they falling on their errors and omissions policy?
Generally, what I see, what my experience has been in terms of researching a lot of these claims, has been errors and omissions.
So they're using it,
right?
At least.
Right.
I'm thinking, I write a lot. My errors and omissions covers not only my normal practice, but I talk about things in a specific area. You're saying holding out tomorrow. We're going to do all tomorrow about the expertise issue. Holding yourself out as an expert in a certain area, maybe not a good idea. I don't know, we'll get that tomorrow. But as we're closing out this segment, in your experience, you've seen errors and omissions come to the plate. I want to use my errors and omissions policy judiciously as a producer. Sometimes the damage is not that big a deal. Maybe I should just write the check. No, it is a big deal. It's way beyond. I don't want to go to my savings account to pay for this. Maybe I ought to do it. Is there ever a demarcation line that you've seen where most producers say, hey, I'm going to just write the check, or no, I'm going to fall on my E&O sword?
I think most producers have been instructed by their carriers that even when they suspect a claim is relatively small, that they should put the carrier at least on notice. Their decision to later then pay the claim on their own may come, and that's, I think, relatively typical. But as a dollar baseline, I think that is highly dependent upon each individual insurance producer. And let me just say, it may also depend on whether or not we're talking about captive agents who work for one single insurance company versus an actual broker or independent agent who represents multiple companies. And so the errors and omissions kinds of coverage that you're going to get may differ. And so that might actually change the response that I gave a little bit earlier in the show.
Well, that's all the time we have for today's show. Remember, before moving forward with any of the ideas you hear on our show, always consult your tax advisor, legal counsel, or your broker-dealer compliance officer. Missed an episode? Just hop out to our site, downtobusiness.ashbrokerage.com. And remember, you could be wiser as an Ash Brokerage advisor. I'm Steve Savant. We'll see you tomorrow.